I would like to begin by reading out a statement. We are here for a case management conference in the matter of CFI 009-2020 before His Excellency Justice Nasser al-Nasser. The claimant is represented by Al-Sharif Advocates and Legal Consultants. Lead counsel is Stephen Doherty. The defendant is represented by Hamdan al-Shamsi Lawyers and Legal Consultant. Lead counsel is Hamdan al-Shamsi. Thank you.
Good afternoon. Welcome to the DIFC courts. I think we'll start with the claimant.
Apologies, Ron. I think I may have just cut out on my connection, but hopefully I should be back now and you can see and hear me.
Yes, I can see and hear you now. Can the defendant see and hear the court?
Yes, Your Excellency, Your Lordship.
Okay.
Connection is a little bit slow, I must say, so if there's any issues with the connections, please let me know.
Thank you. Mr. Doherty, you may start, please.
Yes, thank you. You may have gathered from a brief review of the documents that this is a claim being pursued by the claimant who's a subcontractor against the defendant, who's the main contractor as part of the Alcor development project. And the contract's in relation to the supply and installation of external aluminium, glass, handrail work, etc. The claim itself is a relatively straightforward one. The claimant says that it was owed a total of just under 7 million dirhams under the terms of the subcontract, as it was varied by a number of different variation orders, of which only a little over 4 million dirhams has been paid to date, and the claim is for the balance of the amounts claimed to be owing. The defendant's position is, first of all, that it disputes the quantum of the amounts owing under the subcontract and makes a number of further allegations on entitlement. In effect, it says that it was entitled to make certain deductions from the claimant in relation to three things principally. Its non-conformance reports that were issued by the employer to buy properties, deductions in respect of contra charges, and deductions for liquidated or delayed damages. And there's no counterclaim at this stage. And Your Excellency, there are a few issues, I think, before you today at the CNC. I don't think that any of them are overly troublesome or not capable of resolution between the parties. In effect, there have been exchanges of competing lists of issues. I think in substance, there's probably not a huge amount of distance between the parties on that. It's probably more a question of trying to simplify the list of issues to put it in a form that's a little, I think, more straightforward for the court and of a little more assistance to the court. The second is the case memorandum, which hasn't as yet been agreed, but I think that subject to a few tweaks of the language, I think was perfectly capable of being agreed. And as Your Excellency will note, the document's really there to assist the court. It's not something that's binding on the parties or is going to, I don't think, merit too much intense debate, if I can put it that way. And then the real issue, I suppose the more substantive issue, is setting dates for particular directions. The main substantive point of difference between the parties on directions at the moment relates to expert evidence, so we'll need a way forward on that. And one of the issues I'd also flag from reviewing the parties' case management information sheets is probably going to be determining what the likely length of trial is going to be, because I think both sides realistically on the case management information sheets have underestimated, I think, how long this matter is probably going to take to be heard. So that's a snapshot, I think, of where we are. I'm in Your Excellency's hands as to which order we'd like to go about, I suppose, tackling those issues or trying to card a way forward.
Any response from the defendant?
Yes, Your Honor. So I think I would disagree with my learned friend in relation to the. I mean, in this CMC, we're unable to agree on a bundle, which we find it to be will certainly make this case take longer than usual. We have hoped that we could agree between us to reach certain decisions faster, but we are not, unfortunately. There are extreme differences between us in relation to the claim itself. There are extreme differences. It should be a very easy matter to resolve, but unfortunately, that's not happening. Which I expect from my little experience, I'd say, in the courts compared to your honorable sir, that this with the claimants, or we believe the claimants' claims, which appear to be completely untrue according to the documents. So we believe that, I mean, we've submitted a draft.
Mr. Hamdan, there is an issue with the connection. I think it lags for just seconds. So there are things I missed in your statement.
Apologies, Your Honor. So I will speak slower, if that helps. So, Your Honor, in summary, there are grave differences between the claimant and the defendant. We were unable to agree on certain basic things, including, for example, the amounts that were paid. The claimant has mentioned several times that we are misrepresenting facts, which we believe to be a very big statement from their side. Therefore, seeing the circumstances as they are, we believe that this case will drag on. Was that clear, Your Honor, or was there any interruption?
Yeah, there was an interruption from the word if.
If it continues this way, Your Honor, I'm just mentioning that, for the sake of the claimant wants to do things, we don't believe this is possible. Therefore, we believe our timetable properly represents the amount of time this case needs.
Today we will resolve those issues between the parties and set a timeline, which is the purpose of this case management conference. So the issues which are related to the list of issues or the case memorandum shall be resolved today. And then the timetable, which was filed by each party, will go through it again also together until all the issues are resolved and there is a clear timeline for both parties to comply with. I'm confident that both will be supportive and helpful. Yeah. So as the claimant mentioned, let's take the issues one by one. So let's start with the list of issues. I think it's better to start with the list of issues. which the claimant has comments on.
Yes, Your Excellency. You'll find the two different versions of the listed issues on the case lines bundle. So there are two bundles. There's bundle B, which is the claimant's documents, and the claimant's listed issues is at tab 5. And the defendant's listed issues is then at bundle C and tab 7. Your Excellency, what I had attempted to do in order to try and reconcile this, because it seems as though there are a few issues where really an issue is stated twice, where in fact it may well be the case that it's actually one issue that can be put in a slightly more succinct way. What I've tried to do is to take effectively a composite of the competing listed issues and put them into a list of what I have as effectively 9 numbered bullet points. And I don't know if it's worth potentially going through those, in essence, one by one, to see if my own friend agrees that they do adequately capture what the issues are in dispute, or if he thinks there's anything that's been missed off from the listed issues that the defendant has prepared. But it just seems to me that it might be a slightly more straightforward document for the court than the two tables that have currently been prepared, and should hopefully bring some of the issues together.
Again, please.
I was just saying that I've prepared what I think is a document which should hopefully bring together some of the issues, and I don't know whether it would assist if I read out what I see to be the common issues when one reads both the claimant's listed issues and the defendant's listed issues. And my learned friend will be able to tell me whether or not he agrees with those. But that's effectively derived from reading both parties' documents and trying to put it together into one piece.
But those are the only agreed issues. Yeah, common issues between the parties.
I believe so. My learned friend, I'm sure, will tell me differently if they're not. Perhaps if it would assist, I could send that document to your email address now so that you can see what it is I had in mind as being the common issues. And it might be a more simple working document for the parties to look at. I'm happy to send that to my learned friend as well.
Yes, please.
Your Honour, can I check what the best way to get that is? If I send it to the registry email address, is that something?
Yes, please send it to the registry address. Does the defendant have a copy of?
No, I'm going to send the defendant a copy now. I put this together this morning when I was trying to reconcile the differences between the parties. Mr. Al-Shamsi, can I just check what the best email address to send this to you on is?
Just my email now. If you could put it in the chat as well. And there's also Nandini Tiwari, who was junior associates at our firm.
It's Nandini Tiwari.
Tiwari.
So it's ntiwari at alshamilegal.com.
Yeah, you got it. Yeah.
I'm sending that now. All right, sent, and if you could let me know if you received that document, I'd be very grateful. And Your Excellency, that has gone to the registry's address. I don't know who is on this call from the registry, but if they were able to forward that to you.
Not yet.
Mr. Al-Shamsi, have you received the document? Sorry, I didn't quite catch that.
Sorry, just this second, yes. Sorry, we did.
Perfect. Perfect. Great. Well, thank you very much.
The courts also received the document.
Superb. Thank you very much. And Your Excellency, I suspect the best way then to compare this document to the position might be to then open up Bundle C, tab 7, which is the defendant's listed issues, to see if there's anything on there that's not captured by this slightly more succinct version of what I'd hoped would be the same document. And I'm happy to walk Your Excellency through that, and we can even discuss the points as we go.
I would like to first hear the defendant's comment on the document, then.
Yes, Your Honor. I'm just doing if the courts can allow me just 5 minutes or less.
Okay.
Your Honor, I think I can agree with my learned friend that the first of the list of common grounds that he's put is and forgive me, but I'll need to afterwards during this call. The second
the first is what?
part is the first is
the first part,
correct. Is correct as a common ground, common ground. Sorry, I'm just got lost between the.
Your Excellency, and also I suppose Mr. Al-Shamsi as well, I'd be happy to go through and explain how I saw this document as compared to the second defendant's list, because that might help Mr. Al-Shamsi see where the document has come from and to also know whether he disputes any of the points that we raise, and it might help, might assist you in formulating any requests for clarification.
Yeah, I would.
Disputes.
Yeah, I would agree. You could explain, please. Please.
If Your Excellency is happy for me to proceed in that way.
Please proceed.
Issue 1, the total value of the subcontract works in respect of the various different amendments seeks to capture, if you're looking at the defendant's list of issues in tab 7 of bundle C, so that's issue 4 of the first column in that issue.
Yes.
Issue 2 in the document saying, did the claimant execute the works under the subcontract? In my submission, I think that probably captures both issues 1 and 2 on the issues of fact, which is effectively, did the claimant execute the works under the subcontract, or is it in breach of any of those provisions? Seems to be the same question for the court, really. And so I've tried to consolidate those 2 points under issue 2. What are the sums due to the claimant by the defendant under the subcontract seeks to capture the first part of issue 3, which is whether the defendant owes any monies, and also issue 6, which is what are the total amounts paid to the claimant by the defendant, and tries to bring those 2 questions together. Issue 4 then asks, once the court establishes what sums may have been due, is the defendant entitled to make deductions for the non-conformance report, for contra charges, and for liquidated or delay damages? And that brings together a number of different issues. So it's the second part of issue 3 in column 1. It's issue 7, 8, and 9 in column 1 as well. Yeah, so that consolidates a number of issues into one question, which I think might be an easier way for the court to think about it. Issue 5 then is what are the total amounts that have been paid to the claimant by the defendant, which is an issue because I think there are disagreements over the numbers, but that's again, that's issue 6 in column 1. And then 6, 7, 8, and 9 are the issues on column 2, which run from issue 2, 3, 4, and 5. Which I think captures everything that's in that list of issues, with the exception of what's set out at issue 5 on issues of fact, which I draw to my own friend's attention in fairness to him so that he can formulate a response to. Your Excellency, the reason I've left that out as an issue is it seems to me to be more a question of the party's submission which relates to the other issues. So it's questions about whether, in pleading its case, the claimant is correct in what it says about particular documents. So, for example, when it relies on a particular certificate as entitling it to payment, whether or not that is what the document says or not. It seems to me that that issue is probably a question which is caught by issues, for example, 3 and 5, which is what sums are due to the claimant and what's being paid. And they're probably issues in due course that the parties will make submissions on at trial, but they aren't necessarily something for the list of issues at this stage. So that's the rationale behind leaving it out, to keep the the statement of the issues that's before the court concise, simple, and easy to understand?
Your Honor,
Yes.
apologies, sir.
Yes, Mr. Hamdan.
Yes, what I would have said, it would have been prudent for us to have agreed something like this, and I think my junior Ndini actually was in touch with the claimant solicitor to agree, and then she's made a markup of the list of issues. Unfortunately, that would have, finishing that would have provided the courts with less time to go through right now and analyzing what's different, what's not different. But I could agree with some of.
Are you there, Mr. Hamdan?
We've had on our list of issues, because it just it focuses on the execution of it. Is there a breach? Is there non-conformance, and all of that? The fourth point, which he mentioned, that it covers all the list of issues that we've had. We actually, in the list of issues, also are considering whether we have a right to claim anything. Now, we have not yet put in a counterclaim. However, we'd like to keep it available to us in case we do. If the claimant is correct to say that, the amount, well, if his amounts that we've paid is correct, then there might not be a counterclaim. However, we believe that we've paid more than what he is alleged. And then to the points of this in my learned friends list of issues. A common ground. So rather than take the courts through a point by point, we should have agreed, obviously, before this CMC hearing, and which we have tried to do. And I think perhaps for the better use of the court's time is that we take this list of issues that my learned friend says that they're common, and we respond to them with our amended red line version.
I agree on that.
Yes, Your Excellency, for what it's worth, I can see the sense in that. It sounds like if Mr. Al-Shamsi and I have a discussion about this, I think we'll be able to come to a landing on an agreed list of issues, or even if there are one or two minor differences between us, we can flag where those discrepancies exist in the document, which we can then file with the court after today's hearing, if Your Excellency is content to proceed in that way.
Yes, I agree with that. And the next is the case memorandum.
Yes, Your Excellency. I think probably the easiest way to illustrate what the difference between the parties was on this is if you look at Bundle B, tab 3, you should find the claimant's version of the case memorandum, which sets out what is considered was a relatively concise statement of the parties' positions. Now, Your Excellency, of course, will be aware of what the effect or the lack of effect that a case memorandum has on a party's position is. If we go to the defendant's version, it's in Bundle C, tab 6. And in effect, I think the issue was that we obviously see here quite a lot more detail, including, amongst other things, extracts from documents referred to in the defence and so on. I think the principal issue between the parties is probably the easiest summarised as being a difference of opinions about what a case memorandum ought to be. I think it's really a question of putting the case in brief and neutral terms as rules suggest. And I think that that's where the principal objections and the principal difference between the parties came from. So, for example, I think the claimant finds it difficult to agree to language, amongst other things, suggesting that there had been an attempt to mislead with evidence and things like that. With that all said, I think that there may be scope for there being middle ground on the case memorandum. Again, and it's a matter for Your Excellency, it's something that I would quite happily pick up with Mr. Al-Shamsi from, using his document as a template to try and, I suppose, neutralize some of the language and terminology used, to see if we can agree that as a working document that will be of assistance to the court whenever it picks up the court file. Or if there are any points of disagreement in the language, it might just be that we flag that in the case memorandum itself for the court. But it might be that Your Excellency will find that the most convenient use of the court's time will be for us to go away and put our heads together and to do that in a form that's acceptable to both parties and the court. But I think that the main point would be to give the parties a steer as to what this document isn't, which is a further pleading.
So you don't agree on the case memorandum filed by the defendant?
No, we don't. I think it's a matter of it being which restates or repleads the defendant's case, which is not what a case memorandum is supposed to be.
What else? Ramdan, any comments on the claimant's comments in relation to the case memorandum?
Yes, Your Honor. I think, in summary, the case memorandum does mention the fundamental points about this agreement. However, again, it always, our differences between the claimant and the respondent is that we should, I think, agree to disagree at this point with certain figures. So we have certain figures, they have certain figures. And I think what should be mentioned at first is what has happened and what we're dealing with. And then perhaps we're happy to mention that there's disagreement in the numbers. I think the problem that happens is when we come to numbers. So obviously the claimant's position is that they should put numbers. And our response was that, well, then these are our numbers as a result. So I think that's where we disagree. So I think the best thing is to put both numbers and list out everything, really, because there was, in the case memorandum of my learned friend, they did not mention the non-conformance part, which was very important, which we believe is important, and why we believe sorry, Your Honor.
So the differences are only on the numbers?
And also points. And also
the point
points,
of you mean the point of non-conformance, yeah?
Yeah, so we contend that there's 3 reasons why the amount owed is not what the claimant asserts. That's the first, there being delay penalties. The second, non-conformance, the works weren't executed properly. And then the third point being contra charges. Sorry. So, Your Honor, there are some agreed positions, and I think my learned friend, yes, he mentioned that we rely on evidence to a certain extent. However, how are we to do so otherwise if the parties have agreed on the final payment certificate, they've signed it? So I think it is important to mention in the memorandum, at least, that there is a position that both parties have have really signed on to. I don't believe this should be left out. There's certain things that are signed between the parties that I think will do us a big favor, I think, in reducing the amount of time for this trial. However, if we do not agree on them, that means, and that's why our timetable is a little bit longer than the claimants, we will certainly take much more time, which is fine. However, we just want to, we were hoping to reach a midway position with the claimant.
Your Excellency, I don't know if this would be a suitable way forward. It seems to me that there's two potential positions. One is that the parties wouldn't be in a position to agree the case memorandum, and there would just have to be two separate ones standing in the court file, which would be fine. We could leave it that way. But it seems to me that it might be more useful for the court if, in the context of the fact that we're going to look over and try and agree a joint listed issues anyway, whether I can send a slightly updated version of Mr. Al-Shamsi's version of the case memorandum to him at the same time, and we can see if we can get a composite document that will be the only case memorandum on file and one that's in a form which is easier for the court to pick up and use when it's trying to read into or understand the case, and file those both with the court at the same time.
You agree, Mr. Hamdan? I think, yes, Mr. Hamdan?
Apologies, Your Honor. Certainly, yes, I do agree. One case memorandum is what we should be doing. Perhaps, yes, you may also, Your Honor, make a decision that there be two. However, myself and my learned friend would, I think we can reach a case memorandum that's acceptable to both of us.
If the parties can reach a case memorandum that's agreed by both parties, then the court welcomes this case memorandum. But so there are two. So before me to do the list of issues and the case memorandum, the parties are willing to agree on. So we don't want to just after this hearing go back to this point again where both parties discuss again and just don't agree.
Yes, Your Excellency. I think probably what I would propose to do is, if there are points of difference, what we will do is flag that in the body of the document itself, so that there's still one document. It is agreed that it stands as a document, whether or not the parties agree on each particular approach. But I think that given its limited impact on the overall course of the case, it just makes more sense to have the parties produce one document that both can live with. That would be fine.
I agree with this. Yes, I agree.
From my end as well, Your Honor, we agree with that. And if there's anything that we disagree on, we can put it to one side or at the end of the document, making it clear to the courts.
You can flag it just, and whether it's you can just prepare it the way you like, but at least it's available that in one document what are the agreements and what are the disagreements.
Yes,
so I think both issues are resolved or partly resolved, but then after the hearing, I'm confident that both parties will agree on the sufficient case memorandum. So the remaining is now the CMC timetable.
Yes.
Yes, sir.
I think that there's not there's a reasonable amount of common ground on most of what should be in the case management order, subject to some differences on dates. I think the main issue of substance that we would seek Your Excellency's direction on is likely to be as regards expert evidence. Because of the nature of this claim, the claim itself is largely one which is based on a question of what is the contractual entitlement, has it fallen due, and has it been paid. The way the defence is put is to raise issues which are perhaps of a more technical nature in relation to contra charges on certain other deductions made by the employer, which filter down, it's said, to the claimant, and in relation to issues of delay to completion of the subcontract works. And it's in relation to those issues that in the case management information sheet, the defendant has suggested that it would seek to rely on expert evidence, and particularly evidence in relation to delay and quantum. Of course, Your Excellency, it's within the adducing or not of expert evidence really is a matter in the court's control, and the court has power to decide what the most effective way to deal with that issue is. From the claimant's perspective, it's been a little difficult to form a complete view on what is or isn't needed from its perspective, in part because of the way the defence is put. And if I can draw Your Excellency's attention, for example, if you go to Bundle C, tab 4, page 36, we can see how...
Which page?
Page 36.
Bundle C, tab 4, yeah?
Yeah, see tab 4, page 36, and I'm looking at paragraph 46 onwards.
Just a minute. You're looking at amount deducted as the delay damages?
Yes, that's right. So this is the portion of the case in which the defendant is suggesting that expert evidence is required. And that may well be correct. The issue, I think, from the claimant's perspective is it's difficult to say how technical or not the issue is, because what we have is in paragraph 46, effectively, the allegation that the claimant delayed completion of the works by 408 days. But what we don't have is the breakdown of what the delay events are said to have been, who's said to have been, or what's said to have been the root cause of that delay. We don't have the sorts of delay analysis that you sometimes get in cases which would generally be formulated by an expert in due course. So for that reason, the claimant's position on experts, well, really there are 2 points. The first is, given the value of this claim, the court may take a view that a proportionate approach to dealing with these issues may well be to have one expert appointed by the court, provided that there are sufficient parameters for what a court-appointed expert might report on. And of course, I'd be in Your Excellency's hands as to whether or not you think that that would be a suitable approach in this case, and we're open to discussion. If it were to be the case that there were to be party-appointed experts, the claimant would make a couple of observations. The first is that on the case management information sheet for the defendant, I understand that they've indicated they might wish to call 3 expert witnesses, which I'm not sure what the basis of that suggestion is. The only issues which it seeks to rely on expert evidence, as I understand it, are delay and quantum, which would be at most 2 experts. And in fact, Your Excellency will no doubt be aware that there are expert witnesses practicing in the UAE who deal with both delay and quantum. So it may even be that the parties can have one expert each dealing with both issues. So that's one point that the claimant would flag, and the other is, perhaps more importantly, because of the way the defence is pleaded currently, which is that we don't have the detail of the specific allegations relied on, that were there to be party-appointed experts, it would need to be sequential exchange of reports. So we would need to have the defendant's expert reporting first, and then the claimant's expert responding to that, because otherwise the claimant doesn't really have anything to be reporting on. It would need to be responsive to the evidence that's held by the defendant and put together in a way by the defendant.
First of all, it's party-appointed experts. The court does not appoint experts. So either the parties agree on an expert, or each party shall provide his own expert report. The expert shall then meet and agree and disagree. And if there were two expert reports from each party, a different expert report, those both will be provided to the courts. And if the parties agreed on one expert, then there will be one report only. So what will happen is it's either the parties to agree, but if the parties disagree on an expert, each party will present his own expert report. And I agree with the claimant. The defendant has a different calculation. I agree that the defendant provides his expert report first, and then the claimant to respond on the defendant's expert report. I think this is...
On the draft order, perhaps what we can make provision for, in light of your observations, is parties have permission to rely on experts in the fields of delay and quantum, and we can perhaps put in a paragraph below that to say if the parties agree, a single expert may be instructed to address the court on both issues, something like that.
Yes, if the parties agree on one expert, it's fine. But if the parties disagree on the expert, each party shall present his own expert.
Yes.
But then, yes, as you're both aware, in the end, costs will be costs in the case. Yeah.
Of course. With that in mind, Your Excellency, I suppose that the only thing to go through then is timing for various different steps in the directions.
What's the agreement and the timings?
I think that effectively, I think the difference is that each step from the defendant's perspective is pushed out a little bit longer than it is in the claimant's. There's nothing that's wildly different. I think probably the best thing to do would be to go through the draft directions and to fix a date for each, because then when we come to expert evidence, that might have a knock-on effect on what the likely trial window is going to be anyway, because the parties won't have built into that the sequential exchange of expert reports as yet. So it may well be that the best place to start is if you go to bundle B.
Okay.
The draft case management order is at tab 4. This is the claimant's version, and I can take you through what the difference between the parties is on the different dates.
Let's start all over again and start with the draft and go through the dates again.
Yes.
Can I explain the defendant's position? It might help before we get into the timetabling, or do you wish to hear the claimant? Yeah, so I would start, Your Honor, by saying this: the case, unfortunately, the defendant's position is technical, and the claimant's position is less technical, because we are saying that there's delay from the other side. We are saying the works aren't executed as good as it should have been, and the contra charges. So I think, Your Honor, it would be maybe perhaps prejudicial to the defendant if we make this case, if we reduce the amount of evidence for this case, because the defendant's defense is technical. And the reason why we don't owe this amount of money is because of technical grounds. So whilst my learned friend mentioned that it could be reduced, I mean, the amount of experts and evidence can be reduced, I would beg to differ, only because we actually need to prove that technically there was an issue and quantify this issue. Now, as in relation to, I just want to take a snapshot of the building, Your Honor. The building is 300 apartments, and the works related to aluminium works in those 300 apartments, and other than the lobbies and other common areas, including the railings, including other works as well, with the 3 variation orders. So, Your Honor, you can appreciate that, unfortunately, every single apartment matters. And the report that we have with Dubai Properties, they're quite I would say a very technical client, and they have caught us on a lot of those points. So if you just, if your courts can appreciate that 300 units is a lot of units to go through to check which had issues, which didn't have issue, and just wanted to let the courts know that the building right now is occupied, so we'll need to actually go sometime. Did repair the works or not, bring evidence in relation to that. So it is not as, I mean, it is important for us to defend ourselves, but it's not easy because we have 300 units to deal with and we have to prove them. Now, when we ask for a quantum and delay expert, they're 2 different things. The quantum goes to each apartment, gets the evidence, and decides out of those 300 apartments how many actually have issues, have not issues, and then you quantify that. With the delay, if it was the employer-contractor relationship, it's very easy. It's easier, to figure out the delay, because you just have one date in which you need to hand over the project, and that's it. But we're dealing with subcontractors and how the works enter and are amongst one another. So they overlap one another, subcontractors, and to prove that the aluminium was mistaken or delayed, or actually the civil contracting was delayed, or the MEP was delayed, it's much more difficult than general contracting cases with employer and contractor arrangements. Therefore, I think I don't wish to overlook the complexity and the need for experts, and how complex it will be. And it is, our defense as a defendant is technical. The only way we are able to defend ourselves is proving technically why the claimant doesn't deserve the amounts of money under the contract. Therefore, whilst his opportunity to defend his case.
Mr. Hamdan, therefore what?
The defendant, pleases the court, should have, the ability to defend its case in its entirety.
Definitely, Mr. Hamdan, you have the right to defend your case, and I agreed on an expert. So you'll have to provide the report and the claimant to respond on this report. Unless the parties agree on an expert which they both agree on what this expert will find.
And we agree with that position, Your Honor. I just want to mention as well, there are witness statements, cross-examinations that we would like to conduct, and evidence that we'd like to submit. So I don't know that my learned friend's position on that. I think my learned friend was, if we could hear my learned friend in respect of those witness evidence, I thought there was some reservations there about having witness evidence.
No, you're absolutely. I think it's the normal course of the DIFC courts that witnesses will tender their evidence and will appear and be cross-examined. I think that there's no obvious reason why that wouldn't happen in this case, unless the evidence is not disputed, in which case, of course, there'd be a need for cross-examination. But we won't know that until we've got the witness statements. Your Excellency, to try and assist in moving things along, I've emailed to my learned friend and his colleagues and to the registry a Microsoft Word version of the draft order, which might be the easiest way to work through it. And I can update the document as we go so that we've got a draft order at the end of this hearing, which I can then send to Mr. Al-Shamsi, and if he agrees that it reflects our discussions, we can then send it to the court so that it can be issued.
Yes, that's fine.
So again, I don't know who's here from the registry, but if they could forward you the email which was sent just a couple of minutes ago with that document, that would be extremely helpful.
I received the document.
Mr. Al-Shamsi, have you got the document as well?
Just waiting on refreshing the servers. Say I've received that.
You received. If you both have the document open, what I would agree, or what I would suggest that we do as a new paragraph 1, first of all, is to add a paragraph that says an agreed list of issues in case memorandum will be followed with the court by, we can fix a date, perhaps 7 days from now or 14 days from now, I don't mind. And if the parties cannot agree, they will point out any areas of disagreement.
You mean the first part, yeah, the agreed list of issue?
Yes, so just putting in an order to reflect the fact that the parties will file an agreed list of issues in case memorandum with the court.
I think 7 days is enough.
Yeah, so that is. Let me just get my calendar.
Can I just suggest something that the expert issues only, get decided or start getting reviewed with expert appointed once the witness of facts are and its reply are there. And I think from the witnesses we would have a list of issues for experts to decide between them. Sure, there's going to be different. And I think the best is that the expert is appointed after the witnesses.
It is after the witnesses, Mr. Hamdan.
Yes, I think we're probably in agreement there that the experts would benefit from seeing the factual evidence.
Okay.
Their reports will follow witness evidence. Although obviously it would prevent the experts being instructed and to start work before. So Your Excellency, paragraph the new paragraph 2 would then say the same, or the old paragraph 1. Under the heading production of documents, the difference between the parties here, I believe, I should get the in this case management order. I think both parties have agreed on production date for documents on 14th of June. I understand that's agreed by both sides.
I think we need more.
I think I understand the defendant's
I believe we need much
more time in what exactly? Standard production? And then on standard production, more time or request to produce?
But my understanding of the parties' position.
Your Honor, apologies, I do have an issue.
What's the issue, Mr. Hamdan?
Apology, I'm a little bit blind. Yeah, I've received the email on my mobile. Just on the desktop, it seems to not be. So I was the email on my desktop, Your Honor. So apologies, it seems synchronizing or that sort. So I'm going to just go. If you would allow me just 2 minutes just to resort out things.
Yes, sure.
Your Excellency, just looking through the defendant's proposals for production of documents, I think that with the exception of their paragraph 7, we can probably agree to the dates that were suggested by the defendant. So that would be paragraph 2, standard production of documents, by 14th. Paragraph 3, request to produce by the 21st. Paragraph 4, objections to requests by the 28th. 5, for objection to requests for the court to determine. And I think that the difference there is 14 days rather than 7 days, so that would be the 14th of July, which I don't think I have an issue with. Paragraph 6, the party shall comply with the terms of any disclosure order 14 days thereafter, so that's the 30th of July, 2021. And then I think the only one which I think on the defendant's directions doesn't quite make sense is, and I think it's just a follow-on calculation error. Paragraph 7 is where there are no objections to a request to produce, the document should be produced within 14 days after that. And the defendant has put 15th of August, which would be 14 days after the previous step, which is not what it should be. It should be after the request to produce, so 14 days after the 21st of June. Because I don't think it makes sense that the last step would be producing documents to which there's no objection to producing. That should come before those which are objected to. So on that basis, if we just tweak paragraph 7 on the defendant's set of directions from the 15th of August to 14 days from the date of the request to produce, which would be the 21st, 28th. That would be 5th of July. So I'm happy to run through all that again, but that's really just adopting what the defendant's position has been on all but one point.
Yeah, I'm back. Apologies about that. Just using my mobile, unfortunately, the laptop is not opening the documents anymore. So I think the production of documents, I believe our position and the claimant's position is very similar. By June, we believe then there should be, after June up to end of 2021 should be the witness statement. So I can run you through the dates, Your Honor, if you.
In relation to production of documents, the claimant agreed on the date set by the defendant in their draft case management, except for point 7 or paragraph 7, which instead of 15 August, which I think also it is a typing error. Instead of 15 August, it's 5 July. So this is the claimant's position in relation to production of documents. So they're following the dates mentioned in the draft case management filed by the defendant. Except
right. Right. We believe that, Your Honor, the documents are. There are a lot of documents that we may not find in our hands because of the employer. Simply put, of course, we haven't yet resolved everything with the employer, Your Honor, and we're hoping that by that time we would have. However, we wanted that window up to August to ensure we're able to have time to submit those documents.
Because in those paragraphs where there is objection, you will file the document. You will comply with the disclosure order by 30 July. But here, where it states where there are no objections, it's 15 August. If there were no objections, I think it would be much easier for the parties to provide those documents. I understand your point, but if you read the paragraphs 15 August and 30 July, those two paragraphs, or from paragraph 5 to 7, so 15 August does not make sense with those two paragraphs 5 and 6. So that's why I think that's why we assume that there is a typing error, because paragraph 7 states that if there were no objection to the documents requested.
Right. We just wanted to. We wanted to ensure that by the 15th of August there wouldn't be any more documents. However, we're fine either way. There's 14 days from the request, but I think it's just a final, deadline in case the 14 days is not complied with.
Does the claimant agree with 15 August?
I'm not sure that would make logical sense why the undisputed documents would come after the disputed documents. If the issue is more time, I wouldn't have any objection, particularly to putting that to 14th of July, so that it's coming at the same time as any decision on the disputed documents. Say that would give another week, and then we would have the first tranche of documents that are undisputed coming on 14th of July, and then 2 weeks later, the second tranche of subject to any decision on disputed documents would be coming by 30th of July.
We just, I mean, the reason why we left a fallback position is just that the site is closed, Your Honor. So whilst we'll try to comply with a 14-day, we do want room for certain documents. I don't know what documents, you know. I mean, it's not a matter whether it's disputed or not disputed. It's whether we can get it or not. I think all documents are important for this case, especially that we're fighting on the technical grounds, and we're relying on them. Therefore, 15th of August is the last point where we can submit it, but we'd like that at least fallback position in light of the site being closed. And the site is not in our hands, Your Honor. Neither is it in obviously the claimant's hands. So.
Your Excellency,
there needs to be some time.
It may well be that the answer to this is simply in the paragraph at the end of the document, which provides the parties of liberty to apply. If in mid-July the defendant says we need the other 2 weeks to provide documents, I would imagine that what that will end up leading to is a consent order providing permission for a 2-week extension of time, something like that. But I think for the sake of sort of internal logic within the production of documents, and just for the sake of keeping this course ticking along and not letting time slip by as it invariably can, we should fix the production of documents so that it's all done by the end of July. If there needs to be any slippage, either it can be picked up by an application, or indeed, I'm sure that there will be documents introduced through witness statements as exhibits as well, as invariably is the case too. So it's not the case that the parties' disclosure obligations are going to come to an end on the 30th of July and they won't be able to rely on anything after that. There's quite a bit of way to go after that.
Yeah, well, I mean, what I would respond to that is just that there are other parties involved. We're not the only people involved, and neither is the claimant as well. The site is not in our hands. Whatever documents that need to be produced, we'll need to approach other parties for them. It's not in our hands, unfortunately. If it was, then I would say that you don't need a fallback position, because obviously you need to. But otherwise, you do.
I'll suggest 30 July.
For
both, whether to comply with the court's order or whether standard production where there is no objective. And if then any of the parties requested for more time, either the parties agree or file an application with the courts.
Yes, Your Excellency.
Fine, Your Honor. That's fine, Your Honor.
The next provision I think can just come out, which is the paragraph on judicial reconciliation. Which would bring us on to 9 to 12, dealing with witness statements. The difference between the parties on this at present is the claimant says 7th of September, so that would be between five or so weeks post receipt of disclosure, and the defendant says 15th of October. It may well be that the simple answer to that is to split the difference between the parties and look for a mid to late September date. Perhaps, again, looking at my calendar. So, say rather than the 7th, as suggested by the claimant, we'd be looking at the 21st, and that would give the parties the better part of almost 2 months on witness statements.
So we suggested 15th of October, not September.
Yes.
The claimant suggested 7th of October. The defendant suggested 15th of October.
If the claim suggested 7th September, so there's a 6-week, well, there's about a 5-week gap between us at the moment, but it might be that we find a date somewhere in the middle as a compromise.
Yeah, I would say that we need time for witness statements because they're going to be specific to non-conformance reports. They are a lot, so you need to go through a list of every single part of the project where it wasn't performed properly. And unfortunately, that's how it goes with these cases, because we need to go through every single part that's just wrong, and then the experts might handle that and decide whether we're right or wrong. However, it is a big list of issues, Your Honor.
I think 8 weeks from the 30th of August.
From the 30th of July, Your Honor.
The 30th of July, sorry.
So that would bring us to
30th of September, so 1st of October.
30th of
24th of September, I think, is 8 weeks from the 30th of July, 24th September.
24 September? Yeah, it's 24 September.
Your Honor, I've just noted something which we may wish to bear with me, tweak, which is I've noted that some of the dates we've been talking about, 20th of June is fine, I think may well be Fridays. So, for example, 30th of July is a Friday.
30th of July.
And in fact, it seems it's slightly fallen off the order anyway, because
I don't know whether Fridays, we could change it to a working day. However, these are just deadlines for witness statements for now.
Production.
I think it goes back to production. I think there's been an error which has crept into some of the date calculations. So standard production 14th of June is fine. We've got the request to produce 21st of June. The objections to request to produce within 7 days thereafter brings us to the 21st. Objections to requests to produce, I think, has been potentially calculated wrong, because it says within 7 days thereafter. So that's 28th, and then I think that's where the error comes in, is that the next date has been set as the 14th of July, which would be 14 days after request to produce, but I think that's actually the 12th of July. So 20th of June plus 14 days would be the 12th of July, which is a Monday. So we could change paragraph 6 to reflect that. So instead of 14th of July would be the 12th.
Okay,
and then the parties will comply with the terms of the disclosure order 14 days thereafter. Instead of the 30th of July, that would be the 26th of July, but it's the same 2-week window. And then that would translate across to the same tweak being made to paragraph 7. So instead of 30th of July, we've got 26th. And that way we're avoiding the problem that seems to have crept in where steps are taking place on Fridays.
Right.
And then 8 weeks thereafter, for witness statements, would bring us to the 20th of September, which is a Monday.
Thank you, Your Honor. If my learned friend, if we can, I mean, standard production documents you're talking about in 14 days or 16 days, requests that have to be made. I think if we bring, well, at least add a week there, it'll relax the timetables a little bit.
A week where? In which part exactly? Which paragraph?
Just right off in the beginning, Your Honor. So just the second paragraph, just to relax the days. I mean, we're following the same time schedule, but we just have a breathing space of a week, considering it's summer as well. We need to, you know, it's summer and getting documents.
You mean between standard production and request to produce?
Yes, Your Honor, because you know this is summer and we're trying to get documents from third parties. People are traveling, so if it can end in September, so we have July. To really be effective, Your Honor, I mean, we believe that you know defendant's position is that you know summer is a difficult time to get any documents for that matter. So you know, if the time is not enough, then we would have just wasted that time. Rather, if we make the time enough, then we would make use of that time, because it's a matter of getting a document or not by a certain date, and having that extra 2 weeks is certainly begs considering in light of this, you know, these months being summer months.
So which date you're suggesting?
So I think I'd like to put more, at least 2 weeks extra. And I'm mindful as well that there's a Eid holiday, which will be on the 19th as well, if I'm not mistaken, of July, which again, you know, makes the timetable shift a little bit. So unfortunately, I'm looking at things through my mobile. My laptop's not working, so I can't see the dates of public holidays. So my learned friend, if you could help me there, I don't know if you have a calendar with the public holidays as well. But in general, I would say I would ask, beg the courts for 2 extra weeks in this process. Certainly after the requests are made. Keeping, if the third...
18, 19, 20, 21, yeah, I think this week commencing 17.
Yeah.
17 to 22 is, I think, the Eid break.
Right. And that would mean that we're not getting any documents. Most of the documents are from third parties, so it doesn't count in our favor. If it's a draft of a defense or something, it counts in our favor. However, Your Honor, we're happy to work on Eid holidays, but you know, other people, you can't expect them to work or provide documents on those days. So I would ask the courts to consider, my learned friend, to see that it would, you know, perhaps make more sense if we extend after the requests the time period by 2 weeks to, first of all, the 1 week of Eid that we're going to lose, and second, because we need the extra week just to get documents.
Does the claimant agree?
I think the claimant has already, I think, offered quite a lot more time than it had envisaged for this steps by adopting the steps that the defendant had already itself set out. So I presume that when those dates were suggested by the defendant, it had taken into account those sorts of contingencies, because we've already agreed to what the defendant has wanted. And then I think the suggestion was initially that there might be another week, and now it's another 2 weeks. And I'm slightly conscious that what's going to happen in this case is that the defendant's going to try and continue to kick the can down the road so that it can resolve its issues with the employer, whilst leaving subcontractor out of pocket. So I'm conscious of getting too carried away in delays to proceedings. Perhaps the sensible compromise is we'll take into account the fact that there's the Eid window in July. We'll change paragraph on request to produce from 21 to 28, and then change the other dates we've discussed by 7 days after that, and then allow that to build forward to 8 weeks from that point to the witness statements. That seems more than enough time for the parties to carry out those steps, and that would mean that we're looking at getting towards witness statements effectively 4 months from today, which again seems plenty of time in a claim which is only 3 million dirhams quantum.
What I would say is that, I mean, my learned friend's statement, I mean, we have not yet resolved everything with the employer. That's correct. However, we're not necessarily, intending to delay things here just for that case. But I asked, the parties to just understand that document, especially in the right in the beginning part, it is difficult getting documents from third parties, especially if you have Eid holidays. I appreciate you considering that, and also an extra week would help.
Does the claimant agree or not?
As I say, Your Excellency, if it's a week, we'll be discussing. I think that'll be fine. I think 2 weeks is probably excessive, given that there's already more than generous amounts already for this step. And at the end of the day, the party disclosure obligations are in relation to documents in their control. If documents are not in their control, then so be it. So if that is agreed, Your Excellency, what I would suggest is that the steps that we've discussed would be standard production of documents, the 14th of June. I don't see that there's necessarily an issue with changing that then to, let's say, 21st, which is a week before requests to produce. Then we produce on the 28th.
If you'd allow me, Mr. Doherty, I think my issue was with the after the requests are done, that we have more time rather than when it starts. It's about after the request when we can actually get the document, but how push the 14th to the 21st, that would still, over, it's the objection. So it's the
paragraph 2, standard production on the 14th is fine.
Okay.
Request to produce on the 15th is fine. Objections on the 22nd is fine. And the court to determine on the 29th is fine. The parties shall comply within 14 days. This is before Eid holiday, Mr. Hamdan, anyways.
Right, so I just want to push the 6th paragraph. Am I looking at the right? Apologies, I have yeah, so the 6th, so this is where I'm, sorry,
no, sorry,
this is where,
the claimants,
I was confused as well.
Yeah, again, so you want to push the 6th paragraph, yeah?
Yes, to after July even, because that is holiday. The documents are being requested, and we need to comply in a holiday period. Just be prudent to give more time than and considering that the Eid holiday is then at 16th, I would really push it up to the, if anything, in August.
Your Excellency, the defendant will have had a request to reduce from the 15th of June. Our current position that I thought was agreed that we would get to disclosure by the end of July, that's a month and a half to get hold of the documents, which seems to me to be plenty of time, and even allowing for holidays, even allowing for summer.
Direction comes in though.
And as we discussed,
way
at
after
one time they have liberty to apply. The only reason for going back to revisit these dates was the purpose of correcting them from Fridays to days that weren't Fridays.
Whatever is on a Friday, let's go over again. The first standard production is on the 14th.
Yes.
The second draft on the 21st. Or no, 21st is a Friday.
Yeah. No.
I think we said it had originally been the 15th, so the day after standard production. But were you to make it a week after, it would be the 21st, which is a Monday.
So I think it's best the 21st goes to 23rd or 24th because there's an Eid holiday before then.
No, we this is in the request to produce, which is the third paragraph. It's not the sixth or the seventh. So it is the request to produce.
Yeah, correct.
Date of request. So it's 1 week after the standard production of documents.
Yeah, so 21st of June.
Objections?
7 days would be 28th, which is a Monday.
Okay. And then,
objections would be normally 2 weeks from then, which is 12th of July.
no, objections to the fourth paragraph is 28th of June, yeah?
Yes.
The fifth paragraph where the court determined it's 1 week from the objections. So
5th of July.
5th of July.
Okay.
And the parties to comply on
Yes.
The normal position, I think, that had been suggested was 14 days, but the suggestion was to allow a little more time because of the holidays. So that would be an additional week, which would bring us to the 26th, which is a Monday.
Yeah.
So that would be 21 days after the court's order. And the next paragraph would be the same again. So it's pushing the request for non-disputed documents to the same date so that everything's coming at once.
Yeah.
So then we move to witness statement.
Which, Your Excellency has suggested 8 weeks. If it's 8 weeks, that brings us to the 20th of September.
The 20th of September?
Yes.
Yeah.
Then any witness statement, evidence, and reply within 2 weeks, so the 4th of October.
Correct. But
Then experts.
Your Excellency, I wondered whether, in light of what my learned friend has said about what one might expect from the defendant's witness statements, 2 weeks seems a little short for reply statements.
So what do you suggest?
Probably I would suggest it would be 3 or 4 weeks, most likely. I don't know if my learned friend has any observations on that, but
Does the defendant agree on response to the witness statement?
Yeah, that's a good suggestion because the response would take its time as always.
So how many weeks?
A month is good. Yeah, we need photos and yeah.
I think 4 weeks, because it's going to involve technical disputes. I think doing those witness statements in 2 weeks is not going to be practicable. So I think probably it's going to be 4 weeks. So that would bring us to the 18th of October.
Yeah.
Okay. Then.
Which brings us to expert reports. There needs to be a provision for the claimant and defendant are permitted to rely on expert evidence in the fields of delay and quantum. And then we need a date for expert reports by the claimant shall be filed and served by
So for the list, I mean, we start with great.
8 weeks thereafter, Your Excellency, suggest. Given that.
What's the defendant's point?
So I would say that after the witness statements, there's going to be a lot of points that we want to agree on for the expert, and I think that itself will take, I believe, at least 3 weeks up to a month to decide the list of issues for the expert.
So what do you suggest?
So if it's if the witness statement replies come in by 18th, we mentioned 18th of October, right?
Yes.
Therefore, Your Excellency or Your Honor, that's going to be 15th of November. Right, and then we proceed to either, find a joint expert. That should be quick. We should have 2 weeks to find a joint expert. If we don't, then we go on and we appoint our own experts to submit their reports. I think the experts would need at least 4 months, maybe, at the minimum, or more.
What does the claimant suggest?
The defendant has pleaded its reliance on delay and quantum issues, so it obviously knows already what those issues are. It doesn't need to wait until after witness evidence to start investigating those issues. It doesn't seem to me to be any reason why the expert cannot commence their work and then adjust it as it needs to based on the factual evidence. But it seems to me that given that we've got the factual evidence being filed and served on the 18th of October, the defendant's experts should be instructed long before then, and they can be provided with supplementary instructions after that. But 8 weeks after witness evidence seems to be a perfectly reasonable and usual sort of gap in the practice. 4 months after witness statements, we're talking about not far off, 10 months from today's date, which is, I think, in light of the value and likely complexity of the claim, an excessive period of time. It's dragging on a little too much. So whilst we can see 8 weeks after witness evidence is reasonable, I don't think that much more than that would be so.
Your Honor, we would state that 8 weeks is not sufficient time for a quantum expert to go through all the non-conformance lists that we have. They're exhaustive. I don't think he'd be able to do that. And considering there's a subcontractor claim against a contractor, and there's other subcontractors, he'll have to take the program of works, do his delay analysis along with all the other subcontractors. When a certain subcontractor started, when he ended, whether his works affected the aluminium works, it is very complex. 8 weeks is not enough. Sometimes it's not about the value of claim. It's just a circumstance. We're trying to find out from a delay perspective, out of 20 subcontractors, who affected whom, or at least 4 main ones, who affected whom, and whether the aluminium was delayed or not, or whether we can blame another subcontractor. It's that's what we're dealing with. It's a more complex claim than even the employer and the contractor claims usually. From another part, the other end of what we're analyzing is the non-conformance reports and works they haven't completed properly, plus quantification of each one of them. That's a lot. It's a lot of work. It's not an easy thing to complete in 8 weeks. Is my opinion.
Your Excellency, just to add to that, we're not talking about 8 weeks in total. We're talking about, by this point, around the 13th of December, which is over 6.5 months from today's date. The defendant's pleaded its case. It's presumably done so on the basis of having some kind of evidence on which it could plead that case. It doesn't need to complete witness evidence to get started on its expert instructions. It can get started on that tomorrow, and it can do all of that preparatory work. So 6 months from today's date to obtain an expert report seems to me to be more than enough time in this sort of claim.
I think, unfortunately, I won't have a chance right now to show you all the documents. Probably that will come in 6 months' time and what the expert went through. But I highly doubt that it's not going to be a lot of documents and a lot of analysis. And remember the time. I mean, the technical part of this case is, we don't prove our case technically, we lose, right? So it's prejudicial on us rather than on the claimant, right? Those amounts being claimed by the claimants are the delay penalties, the quantifications, and the contra charges. It's all technical, and we need to prove that. So it's all.
What's your point on why are you waiting for the witness statements to start?
Certainly, Your Honor, certainly there is work that happens in parallel. We're not denying that, as my learned friend has suggested. However, I am very worried about getting, evidence as quick as my learned friend believes that we can get, considering the site is occupied, it's complete, it's handed over to the client. You know, if we didn't take a photo, we'll need to get a permission from the tenant or from the owner, whoever it is, to start going to each apartment one by one and taking photos. That's if as well Dubai properties, you know, don't cause delays in that. And they're cooperative.
If the building is occupied,
yeah,
the work is done. The building is occupied. The work it means that the work is done.
So you're right, Your Honor. We're saying that the work has been completed, but the problem is not completed to satisfaction. There are contra charges, and most likely the employer would have already rectified what was not working. So we need to also gather those documents, gather those photos to prove our case. Unfortunately, we are, you know, feeling that we need to run after the evidence to defend our case, rather than the claimant. I mean, the claimant's position is, if I could say that, allow me, it's a little bit easier than ours, because we need to prove that what he's done is wrong. In the circumstances, the employer has already taken over the site, has probably already made changes, charged us contra charges for those changes. So there's no doubt that, you know, the works have been done and the employer has suffered. As a result, we have suffered. But we need to prove it, right? And and that's upon us to do. So I would ask my learned friend to please consider that, in Your Honor, to please, you know, allow more time for the experts so that proper evidence can be provided to the courts, and we're able to, you know, for us, obviously, win our claim and our defense.
From the 18th of October until the 25th for the parties to agree on an expert.
25th of, Your Honor, November or December?
October. To agree on an expert. If the parties fail to agree on an expert, each party shall present his own expert report, and those expert reports shall be filed by the 3rd of January.
Your Excellency, is that the provision if there is a joint expert? If party appointed expert?
If there is a joint expert, or if there is the parties have their own experts. But I recall that you requested for the defendant to provide an expert report and the claimant to respond.
Yeah, so that would be the defendant's expert reports as well then on the 4th of January, is that right?
On the 3rd of January, yes.
3rd of January, my apologies. Just taking this so we can get the draft order together quickly after this hearing.
So the parties to agree on the 25th of October. If not, then each party shall get his own expert, but the report of the defendant shall be provided by the 3rd of January, 2022. And the claimant to respond.
I think, so on claimant response time.
How
Yes.
long?
So on this analysis, if the defendant has relied on its own expert, it will have had approximately 7 months, I think, from today's date to report. If the claimant is picking this then up for the first time on the 3rd of January, I'd expect probably at a minimum we'd be looking at probably around 4 months to report back if they're picking it up for the first time, because they're going to have to go through all the same issues. So that would be, I think, is it 16 weeks?
16 weeks to respond.
Yes, because of course this is going to be the first time that the claimant has seen any of the delay analysis or any of the delay issues, which I think is going to take quite a bit of time to report on from first being able to pick it up.
So the parties agree on this date.
16 weeks is the 16 weeks is the 25th of April, just for ease to assist the court.
Yeah, 25th of April, that'll be.
And then pre-trial review. I think by receiving the claimant's response, I think then
Your Honor, that includes. Your Honor, just to mention something, is the claimant not submitting or wanting to submit any expert reports? Is that the position of the claimant?
What I believe the claimant mentioned at the beginning of this hearing that it is on the defendant to provide the report and they will respond.
Sure.
Or unless the defendant has a different, unless the claimant has a different view.
That's correct, Your Excellency. The claimant will be providing its reports sequentially in response. The only further step on top of that, which, given the proposed nature of this type of evidence, is probably likely to assist the court, would be a provision that potentially within 21 days after the claimant's reports have been filed, there should be joint meetings of the experts in line discipline to prepare a joint report on what is agreed and what is disagreed, so that the court knows what is still an issue by the time we get to trial.
So this is after you respond.
Yeah, so that would be after the claimant has filed its expert evidence on the 25th of April. Within a period of time thereafter, we would want to, I think, include provision for a joint meeting to take place and for a joint report to be prepared on what's in dispute and what's not.
Okay, so
Your Honor, I would have thought that the parties would submit.
You thought that each party will submit at the same time?
Yes, Your Honor. I thought that was the position, or because the claimant is asserting that he's going to submit his expert evidence on the 25th of April. Surely, then we'll need time to respond.
It is a response on your...
Which is right, with expert evidence, Your Honor.
And
so
then
that will take it up to another 3 months, or at least.
Your Excellency, I think that's the purpose of the joint meeting, which is for the parties to then work out between themselves in a hopefully more collaborative way, rather than, I think one can get into a risk of doing response report after response report without ever actually narrowing the issues. So if we've got one report each followed by a joint meeting, then the parties know what is agreed, what is disagreed, and what's still going to be in dispute by the time we get to trial, which I think is, in my experience, a slightly more helpful exercise than sort of reiterating what an expert has already said out in his previous report.
Not to delay matters, 1 week for the parties to agree on an expert. If the parties don't agree, then each party will present his own expert. Both parties to provide the report by the 3rd of January 2022, and then the parties' experts 21 days to sit and discuss the agreements and what's agreed and the expert reports and what was disagreed. I think this is the best way to do it. If each party 3 months to respond, then I don't think this is reasonable.
Your Excellency, I agree that responsive reports are not helpful. I think sequential exchange does need to remain in place because of the nature of this case. Because what's going to happen before the claimant can comment on any of this is that the defendant is going to have to go do its investigations, set out its analysis, set out its expert evidence, and it's only at that point that the claimant really knows what it's actually responding to. So the claimant won't actually be in a position to know what its expert evidence should say until after.
As I mentioned, each party to present either agree on an expert, or if they did not agree on an expert, each party present its report, and then the experts to meet and agree on the differences and what was agreed in the expert report. So it's expert reports to be exchanged.
But before we get to that point, the issue comes back to what we had discussed, and I think Your Excellency had suggested at the beginning of the hearing, is that the reports would need to be sequential. So we would need to have the defendant's report first, followed by the claimant's report, because otherwise the defendant doesn't have anything to report on, because it doesn't have how the claimant has set out how the defendant has set out its case, what evidence it relies on, what delay analysis it is relying on. So there would be nothing.
The list of issues are the reports should be on the list of issues. It will not be something different or new.
No, I understand that. The issue is until, in a case like this, in a delay case, until one party has set out what its case is on delay, the party that's responding to it can't report on it because it doesn't have the information to report back. It comes back to what's set out in the current iteration of the defendant's defense, which is all that it alleges is that there was a delay. It doesn't explain why there was a delay. It doesn't explain whether there are concurrent delays. It doesn't explain what the underlying cause of the delay was. It doesn't explain how the claimant is alleged to have been responsible for the delay rather than another subcontractor, or in fact the contractor itself. So the issue in this case is that the reports would need to be sequentially exchanged for them to be properly reported on by the claimant's own expert. So we would need to have defendant first and then claimant's report after. And then after that, after a short period of time, we have a joint meeting where both experts will get together and decide at that point in time what they agree on and what they don't agree on. So the principle is the same. Both parties will have one report each. It's just a question of the timing of the reports. So what we had been discussing up to that point was defendant file and serve 3rd of January, claimant file and serve 25th of April, and then within 4 weeks after that we get the joint report setting out what's agreed, what's not agreed.
Then
And then that brings the expert evidence phase to a close, pre-trial review and the steps to trial.
Your Honor, I think I would agree more with the court's view that we understand what the list of issues are. The claimant already understands what they need to prove in this case. Even the claimant themselves, that they were not in delay. It's well known how to prove that you're not in delay, and I think we don't necessarily need a sequential report and response. I think we can both submit the report together. We can both reply to each other's reports, and then perhaps we can get the experts, together. They call it hot tubbing, and they can see if they can narrow down or resolve the differences. That's our position.
Your Excellency, with the greatest respect to my learned friend, that approach just simply won't work in this case. If that was the path that the defendant wants to go down, the first thing that's going to happen is this week the defendant's going to get a request for information so that it can actually plead out its case on delay, which it hasn't done. That's going to lead to more delay in the proceedings whilst the defendant formulates its case in the absence of expert evidence. And we're going to get to the point where what will be required is, if the parties are going to report at the same time, the claimant is going to need to have a responsive expert report, because as it stands, because the case isn't pleaded in detail, the claimant's expert would have nothing to report on, because it needs to respond to the allegations being raised by the defendant about what the delay is and so on. So logically, it can't work without this being a case where there is a sequential exchange of expert reports. It just will end up in a situation where the defendant has taken 6 months to formulate its case for the first time and to report on it, and the claimant is in a position where it doesn't have the documents, it doesn't know what the defendant's going to say about its door-to-door inspection that it says it's going to be carrying out between now and January. It doesn't know what defects the expert is going to report about. It doesn't have access to the site, doesn't have access to the claimant's sort of Primavera or other programs which set out its program of works and why that was affected and who was culpable for that. So none of the issues of these sorts of complex delay analysis until the first report has been received. And it's the same way it would work in most other construction jurisdictions. If this was an arbitration, the defendant would rely on it in its memorial and the claimant would respond to it in the normal course. I think if we were to have a simultaneous exchange, we'd simply get into the position where there are going to be procedural wranglings, applications, and things are just going to continue to be delayed. If the issue's overall timetable,
Your Honor, I would
lined up, but that really needs to be the defendant bringing forward its report and the claimant still providing a report sequentially, but in slightly less time. That seems to be the only way through that concern.
Yes, Mr. Hamdan.
I think a very small reply. Yeah, very small reply from my end. Your Honor, we have submitted in our defense, our pleadings at least, all the documents. So I think for now, at presently, we've submitted a lot of what we have, if not all, in our hands. And there's quite an extensive amount of documents and information to know exactly where we're heading with this, explaining why the delays and the calculations as well for the delays. So we could just go to the bundles and have a look at them right now to understand that they are submitted.
I'm suggesting the defendant's expert to be filed on the 3rd, the claimant's response or expert report or expert in reply to be, I'm suggesting 10 weeks from the 3rd of January. as a response, and then for the experts to meet. We move to pre-trial review.
Sorry, Your Excellency, the joint report, how many weeks?
To be
How many weeks after the reports for the joint report was it?
The defendant to submit on the 3rd of January. The claimant to respond by the 14th of March. And then for the experts to meet 21 days, or to submit the report within 21 days.
Yes, Your Excellency. May I make just one brief tweak to that timetable, which is in light of the 6 months that the claimant now has to instruct an expert, whether an additional 2 weeks might be added to turn the 14th of March into the 28th of March.
We don't have evidence that the defendant will appoint an expert now. I'll take it as the template of the CMC, where the party should file, or as per the rules of the DFC court, a party should file an expert report following the week of closing witness evidence. So I'll consider the 10 weeks from the closing of the witness evidence. That's why I gave you an equal amount of time to respond, and then 21 days for the experts to file the report. To pre-trial review.
So that will be,
if I understand
4th of April.
correctly, Your Honor, 3rd of January, 14th of March, claimant to respond with expert report, or if required, and then 4th of April for reports to be submitted, so for the experts to submit joint reports.
Yes.
That's the 10 weeks and 21 days. Yeah.
Yes.
Yes, Your Excellency. I suspect that means that the next 2 paragraphs can come out because the experts are going to meet. I'm not sure that there needs to be a pre-trial review for that, unless Your Excellency thinks otherwise.
So when is the suggested date of trial?
The initially suggested trial date, I think it needs to go back a fair amount. If we've got the report, if expert evidence is going to be finished on the 4th of April, the remaining steps are going to be trial bundles, reading lesson timetables, skeleton arguments, and so on. I would have thought that that's probably putting us into a trial window beginning probably from June onwards. And one of the things that we'll need to discuss is trial length. The defendant's directions had suggested 3 days. Unless there's a substantial narrowing of the issues, I don't think that 3 days is realistic. What we're going to have is 4 potentially expert witnesses. I think both parties had indicated that, I think the claimant said that there were 3 witnesses of fact and the defendant might have 4. I think we would be hard pressed on the basis of those witnesses to fit this into a week. More likely we're looking at spillover into the following week, so probably around 6-7 days, one would have thought, for 7 to 8 witnesses of fact and 4 experts, and including time for openings and closing submissions.
I think 3 to 5 days.
Yes, Your Honour, I wonder whether would it be either prudent or possible to list the hearing for 5 days, but to set potentially a day in reserve for the following week in case there is any spillover. I've had recent experience of a trial before His Honour Justice Giles where we had made a similar provision and ended up utilising the spillover day.
What's the defendant's view?
I mean, our experience in contracting is that usually things, the cross-examinations do tend to use up a lot of time, and then I think we need more days than less if we had the chance to.
Then we'll go with the claimant's suggestion.
So should I put in a provision for 5 days with a further day in reserve?
Yes.
A trial window, this may be in Your Excellency's hand, but trial window beginning, should we say 2 months after experts have reported? So that will be 4th of April.
3rd of June? 4th of June?
I think we need more time for trial. Trial windows, 2 months.
I also don't know, Your Excellency, if you have the court's availability in front of you, because obviously it's going to be subject to when the court is actually.
Tentative date is let's have a tentative date until the registry conforms with the parties.
Your Honor, I would suggest June.
June date.
Date-wise, that would be say the mid-June week.
Does the
second 6 to sorry. So, Your Honor, if I may continue, is 6th to the 10th, and then spillover day on Sunday, on the 13th. Mr. Doherty.
Yeah, I just wonder whether it might be better to run starting with Sunday, maybe with day 6 of the following week, which would, if evidence goes well, actually give the parties the weekend to prepare the closing submissions. So either, I don't have any particular preference. I believe that my own calendar, but whether it's the 6th, 12th, I don't think that makes a huge difference. We could say starting on the 12th, or the first week long availability the court has after the 12th, something like that.
The first week after the 12th of June?
Yeah, first week the court has available after the 12th of June after a 5-day hearing with 1 day in reserve.
Does the defendant agree?
First day after the 12th of June, that's fine for us. First week, sir.
Yeah, so it's the week commencing 19th.
Yes, the 19th is a Sunday.
So the 19th of June, duration of 5 days with 1 day in reserve. And then
yes. And then I think the other directions probably work back from that. So skeleton arguments.
the directions from let us list the pre-trial, which is 4 weeks. I think 6 weeks is sufficient before the trial date. So
21st of May.
yeah. And then the trial bundle is 2 weeks before the trial.
Yes.
And the reading list and time and trial timetable is 2 days before the trial. So I think Wednesday, Wednesday 15th of June. The skeleton argument, the theme, and the chronology also on the 15th of June. So paragraph 16, 17, and 18 should read, the date should read the 15th of June 2022.
And then I think the only other, did we put in a date for a progress monitoring date, or should that just come out? That was paragraph.
Yeah, paragraph 18.
Yeah.
What do you suggest? What does the party suggest?
Yes, sure. In part, I would say that we're maybe in the court staff's hand as to when they consider, what point in time it's considered that it's helpful to have a progress monitoring date, whether it's, for example, in the middle of preparation of the expert evidence to make sure that everything is in hand and is going to time, or whether you want it slightly later than that, perhaps after the expert evidence, but before the joint report is being prepared.
What does the defense suggest?
Yeah, I believe that a lot of the probably would need that just after the expert reports, considering that there could be. I mean, that's the point where we'll have a lot of perhaps if there's any disagreement, that's where the disagreement would come after the two.
Suggested date.
I would go ahead, Mr.
Yes. What I was wondering is if we got it in between the 14th of March and the 4th of April, which is just before the joint reports, so that if there is any issue, if the court wants to have any say about what the expert reports are going to look like, that would be an opportunity. So, say a week after the 14th of March, so 21st of March could be penciled in, and of course the parties may take a view as to whether, and the court may take a view as to whether that's necessary at the time, and can seek to vacate if need be.
I don't mind if the parties agree on a date. I don't mind.
Yeah.
I put in a provision for both the progress monitoring date and the pre-trial review. Say, if the parties agree that they write to the court to seek to vacate, then the court will confirm.
No, let's set the dates. It's better.
Yeah, set the dates, but I'll include a paragraph to say parties at liberty to write to the court seeking to vacate, but we'll keep the dates fixed one eye.
Yeah.
Okay. And I think that might be everything.
Yeah.
I think it's liberty supply in the usual way.
Yes. Kindly submit the draft to the court, so I'll review it and then issue it.
Yes, perfect. I'll tidy up this version of the draft. I'll send it to Mr. Al-Shamsi together with the other documents, and once we've got everything collated and agreed, I'll send it to the registry.
Thank you. Anything else from both parties?
I don't think so, Your Excellency. I think we've covered everything.
Not from our end, Your Excellency. Thank you.
Then thank you both parties. We'll be waiting for the draft CMC order. And for the two issues we discussed at the beginning of this hearing, I think 1 week is sufficient for both parties to agree.
Yes, and Mr. Al-Shamsi, I'll pick up this afternoon. I'll send you an email and we can discuss if we need to on the phone.
Sure.
So 1 week from now. Thank you both parties.
Thank you very much.
Thank you, Your Honor. Thank you.